Good evening. So great to have you here. We truly know that you have many different ways you could be spending this evening, and the fact that you chose us is an honor and a pleasure. So we hope to make this as fun as can be. You know, maybe Article 9, Article 12 of the UCC doesn't strike you as something that would be a lot of fun, but I think we can make it fun. And it's certainly an area that is important enough that we needed to take time tonight to actually deal with the subject in a way that hopefully will be useful to you. Just in the way of introductions, my name is Henry Moriello. Many of you probably know me from my days at Arnold and Porter. We had the pleasure and honor to move to Seyfarth. We left Arnold and Porter on September 30th, and we arrived here at 8 a.m. on October 1st of last year. So we're here just 120 days, and it's been wonderful doing that. Two of my colleagues who I think you may know, Michael Carroll, who is actually in the middle up here at the podium, and as well Karsten Giesecke, who's in the audience, moved with me. And we had the great pleasure to join Paul Kruger, who's at the far end of the panel, who had a very established practice in structured finance. And so we felt that we were teaming up to put strength on strength. Paul and I had had the great occasion to work across the table for many years, and we always said to each other, you know, someday we should work together. And Paul graciously agreed to allow that to happen. So we're really happy to be here. Also joining the panel to my immediate left is Gordon Puri, a wonderful colleague of ours who's actually is the head of our derivatives practice. So Gordon, thank you for taking the time to do this as well. We're going to do our very best to limit the program to 1 hour because, you know, hopefully the next part of this will even be a little bit more fun because we'll do a wine tasting together. So we want to make sure that you have enough time to do that with us. I would also ask if you would be kind enough, we like to make our time with you as interactive as possible. We're not going to read slides to you. We've left you a 70-page booklet that's intended to be a reference guide for you. And I think you'll find that it will provide some value to you after the seminar is over, because we could not come close to covering the material that's in the 70 pages tonight. So we'll just do certain highlighted portions, and we'll take you through those pages as we go along to give you the gist of what the program is about. And so the title of this program is The Digital Awakening. As you know, more than anyone else, because you're all professionals in your field, is that the assets of the physical domain have been rapidly moving into the digital electronic domain. And that's raised certain challenges into how parties transfer those assets and take security interests in those assets. And so tonight we're going to be focusing on some traditional assets that you're very familiar, those, you know, that are normally called accounts or payment intangibles or general intangibles or chattel paper, that have wide range across all the asset types you work with, from credit cards to auto paper to aircraft leases to rail car leases, and then some other assets which have been gaining tremendous position in our market over the last few years in the nature of digital assets, such as crypto and stablecoin and other types of digital assets. And this time together is intended to try to show how more traditional assets have been moving into the electronic digital domain and how we should treat those. And then also assets which for the first time are making their way in a great way through the finance circle and how we would transfer and secure interest in those. And because we all work on very significant matters, although this topic may not be that which is so compelling to somebody who's looking to see how, you know, you structure an RMBS transaction or a CMBS or a CRE, CLO or a credit card, at the basis of everything we do is whether the assets are there to be counted on and whether you have a first priority security interest in those assets or a first priority ownership interest in those assets. So generally, this is the fundamental of everything we do, because if we don't have the ownership and or security interest in the assets, we actually don't have any deals to do, right? So that's why we're spending the time to do it. So just a little bit in the way of history on the Uniform Commercial Code, because I think this is important. To my knowledge, Gordon, you would know better than I do, but I think the first time the UCC came on the scene was around 1952, 1953. Is that right, Gordon? And we had some significant amendments to Article 9 of the UCC. Now, remember, the UCC deals with many different articles. We're up to Article 10, Article 12, right? And some deal more with leases like Article 3 and commercial transactions, and then some deal more with security interest. Article 9 is essentially that deals with security interests. And security interest is not just taking a lien, but security interests also involve the transfer of financial assets. And so Article 9 of all of the articles in the UCC is probably the most germane and important to you. So in 2001, we had some significant amendments. Many of you will remember it's that which added the concept of a control agreement under deposit accounts, a DACA, which you all use the term. Many of you are experts in that. And now we have what is probably the most significant amendment in the context of the UCC in the addition of Article 12. And as I said, it deals with electronic manifestations of many of the traditional assets and also new assets. To our knowledge, that as of the end of January, I think the last time we looked at this, right, Mike, was January 27th, 33 states have adopted Article 12. Now, when we use the term adopted, please remember the UCC is not a federal law, so it has to be adopted in each jurisdiction where it's effective. And so there are also differences from jurisdiction to jurisdiction in the way it is adopted. And although it was essentially has been adopted in 33 states, as far as a focus in New York is concerned, it was signed into law by Governor Hochul on December 5th, 2025. And it will become effective in New York 180 days from the date that it was signed into law. And Gordon did the calculation for us, so I know it's correct. That means it will become the law in New York on June 3rd of this year. So you're on the doorstep of something that's in many ways, in my opinion, transformative. So we're going to now use, with that background, we're now going to use the presentation. Mike's going to do it electronically from here, and then you have your books. We'll just take you to various pages to actually give you a little bit more substance, maybe write in your book any notes that you want. So I'll ask you to take a flip to page 6. And we're going to introduce a really important concept of what Article 12 is really all about. Article 12 is actually presenting the concept of control as the new possession. I mean, that's a very simplistic way of putting it, but probably fairly accurate. You know how all of you, when you have promissory notes, you're panicked about, did we get physical possession of those promissory notes? If not, we're not going to be perfected, or some party is going to gain a superior right to us. Well, Article 12 really now introduces the concept that control is the new method for superior perfection. It's important to realize that in certain asset classes, like promissory notes, just to use that as an example, under Article 9, you can perfect a security interest in them through a filing of a UCC1, correct? And that will, in fact, give you a valid perfected security interest. But with promissory notes, a party who takes possession of them for value and without knowledge of an adverse claim will actually defeat the interest of a party who is done by filing. We are not going to use the word "it trumps" because that may offend some of your sensibilities. So we'll try to use the word, I think, what did we come up with, Gordon? Supersedes, is that the term that probably is? Takes us to superior interest. So think of control as now being the new possession. You'll see in the bullet point, the second bullet point, that this concept is in fact embodied in how control rather than possession actually does that. So if you'll now flip to page 7, and Mike could do it on the screen, we should note that as Article 12 has been introduced, there have been some corresponding amendments that have been done to Article 9. And we don't have the time here to go into all of those, but it's meant to create a cohesive method for perfection in these asset classes. So, and the key element here is what is referred to as a controllable electronic record, or a CER as an acronym. And it's important enough that we'll just take a moment to read together what a controllable electronic record is. Under Article 12, it is a record, and we'll talk about what that is stored in electronic medium that can be subjected to control. Now, if you flip down to the footnote at the bottom of the page, it also defines what a record is. And it's unchanged by the amendments, but it's defined as information that is inscribed on a tangible medium, or that is stored in an electronic or other medium and is retrievable in perceivable form. So that sounds like a lot of mumbo jumbo. But there's a way that you probably all have been using this concept of control electronically through a device that's become fairly popular with certain asset classes over the years, particularly chattel paper. Does somebody want to venture a guess what that is? Remember, this is interactive. And by the way, along the lines of interactive, please interrupt us at any point in which you have a question, okay? We'd love you to have your input, or if you want to add something to the discussion. But, and some of you do this as you're living, because I see people who are involved in the custody business here. But the most palpable example that I can give you of what an electronic record is and how electronic control is mastered is something called an electronic vault. I'm sure you've all been working with that, right, for years? An electronic vault takes electronic paper and creates a method under which there is a verification process, and we're going to go into this in more detail, of how, in fact, that record is maintained and who, in fact, is in control. One more definition, if you would flip kindly to page 8. And control is described as a person generally has control of a CER if the CER itself or the system in which the CER is recorded gives that person, this is very important, the exclusive power to avail itself of substantially all the benefit from and the exclusive power to transfer the CER. For some of you who also operate in electronic documents and are familiar with all of the e-sign statutes, both federal and statewide, this is generally what people, it's not the same concept in the UCC, but very similar, of what is called the single authoritative copy. Is that a term that's familiar to you? It basically is an electronic way of knowing that that copy, which is in the possession electronically of the electronic vault is the only copy that can be used, and the party that is registered as the owner is the only party who can cause it to be altered or transferred. And so that is really what our entire presentation is going to be focused on tonight. Could I take a minute here to just take a break and see if anything that I've said thus far doesn't make sense to you? And don't worry, you won't hurt my feelings if you have a point to make. Because I think this is kind of the fundamental underpinning of what we're going to discuss. So I just want to make sure that we take a moment here in case there's any questions. Okay. Mike, I'm going to ask you to talk about on page 9 what is generally referred to as the take-free rule. Would you do that, please?
One second. Oh, yeah, it's on, I think. So the take-free rule is kind of the analog in controllable electronic records, which we'll talk about in more detail what they are and what they do, to the holder in due course of a negotiable instrument, in part. But the idea is if you acquire control of a controllable electronic record, a CER, good faith without notice of any adverse claims, then you take it free of anyone who may come out of the woodwork and assert a property claim against the CER. So in that sense, it's partly confers negotiability on electronic records, which is really a great thing. It really brings electronic records into the same tandem, the same footing with things like checks and notes, because Bitcoin is also a medium of exchange. It's also and lots of other tokens and so forth, and that's emerging. Should have that quality. You should be able to take some Bitcoin without having to worry about whether or not someone else had a claim to it. How would you even know? So this is what the take-free rule does, in short.
Thanks, Mike. Appreciate that. And so this is all about, right, Mike, priority and the ability to have understanding and confidence that if you bought an asset, it's yours, and if you're taking a security interest, it's yours. Now, we do have a little bit of bad news for you, and this is sort of codified on page 10. And so I know as I look across the room that a number of you are asset-backed lenders, not ABS, but asset-backed lenders, where you're lending against primarily both inventory and receivables. Okay. If you lend against inventory, which generally the UCC would call goods, we don't bring any news to you tonight that's new. If you lend against goods, you still need to have possession of those goods to be perfected in them. And so many of you ask, well, okay, we lend against, assets that are in a warehouse. How are we going to get possession? Are we going to roll back the card and bring them into Deutsche Bank, right, to make them have possession of those assets? No, because normally what's happened is that some party is holding as an agent on your behalf pursuant to a bailee agreement, etc. And that the UCC has not changed. Those physical assets still need to be perfected in regard to possession. So, perhaps we'll figure out a way as time goes on to get a better method for that. But as of now, that is the case. And so we have been talking thus far about some of our traditional based assets, things that you do, right? Things that are accounts, like trade receivables, things like chattel paper, which are aircraft leases and rail leases, et cetera. But now we have a whole new world that we're living in, which generally is digital assets. And I'm going to ask my good colleague, Gordon, to walk us through the whole new age of digital assets. Now, before we do that, Article 12 is ushering in a new medium. So this is like incredibly important because we're increasingly dealing with digital assets. But under the existing Article 9, if you essentially seek to take a security interest in digital assets, generally experts view, unless my panelists disagree with me, the digital assets are generally classified as a general intangible. And generally the method for perfecting in them is the mere filing of a UCC statement. There's so many flaws in that. And how do you describe the collateral? How do you know you can uniquely identify the collateral? And so Gordon will walk us through how Article 12 will provide some new ways in which to look at buying and taking security interests in digital assets.
I don't know. I thought you were well on your way, Henry, of doing such a clear job myself. I don't know that I need to say anything, but excellent. And thank you also for the very kind words. And if Aaron Zimberg is in the crowd, I want to extend a special thanks for putting together all the materials, the nice bags that you have in front of you. So special thanks also to Paul for the technology. As mentioned, I'm Gordon Peary, coming to you from Los Angeles at Seyfarth. Henry's right. All the lenders are increasingly seeing more borrowers coming to them with requests for loans collateralized by these new digital assets. It creates all sorts of problems. Does the lender issue an all asset lien? What does that lien pick up? What about releasing that lien when it comes to digital assets? Let's say there's a default. How does the lender know upon default that the collateral pledged on day one is in fact not encumbered since then? How do we raise the comfort level of even borrowers? Because some of the spreads and some of the haircuts on these loans are so pro-lender that it's not attractive to a lot of the borrowers. Some of these assets are haircut 50% or more. So just like Henry properly said, the way before December 5th, and indeed before June 3rd, 2026, the way the whole market dealt with this was very, very cumbersome, very much fumbling around. Some great creative theories, including one from my colleague to the left, Mike, who wanted to do this under Article 8, which I think is genius, full stop. So this slide here on page 11 basically addresses that reality. Remember that the word in the middle is something what I want you to focus on. It says meant. That's past tense. In the past, people were up to this point, again, up to the signing of this new Article 12, people were filing UCC 1s, hoping to pick up everything and describe it properly with all sorts of these questions. Now, the questions only come up because of the novelty of the assets. And if you look at the next slide, page 12, this is not a Bitcoin seminar at all. This is not a token. We have those seminars if you're interested. The emerging digital assets in the cryptocurrency space are so important, as well as tokens. They say, the Boston Consulting Group counts the market cap for all tokens worldwide to be right around 3 trillion with a T. And the same Boston Consulting Group, literally the elite consultant insofar as new digital currencies is concerned, pegs 2030 market cap of all tokens at 15 trillion with a T. So if you're a lender, you can count on the next several years of getting a borrower in your office that basically says, all right, I want that credit facility, and here's as collateral what we propose to pledge. And so that's the whole point of this seminar is, and in fact, if we get around to it, not sure that we will, and it's okay if we don't, I prepared a nice scenario for you at the very end that basically hypothesizes that exact conversation with a lender and a borrower facing each other, and then how it's treated before the effectiveness of Article 12 and the revisions to the other articles, as compared to what happens afterwards, and how life is made so much easier, in my own opinion, due to that. So anyway, again, not a Bitcoin seminar at all, but these are all native assets to the internet. There's a question, please.
Hi, thanks for that. Just because I don't.
Would you mind if we just get you on a mic? Okay, we want to record you for posterity. I'm kidding.
Hi, Henry. It's
Hi.
Kathy.
How are you,
well?
Kathy?
Thanks for this seminar.
Yeah.
The scenario you have on page 11, it says that the transfer, I guess B, she will transfer the Bitcoin to her wallet via blockchain. Is that possession or is that control?
Oh, that's,
Okay.
go for it.
Oh, sorry. Yeah, no, I was gonna say, we have a colleague that actually was gonna, and I'm getting to your question, but it's kind of a funny.
Let's go right to the question, Mike.
We can do that. We can do that. So the footnote is really dealing with this situation where you have Bitcoin that's transferred, which is transferred, and I hope I'm getting your question, via, private key. So, and it's transferred to the blockchain. So if, but, under Article 9 that pre-exists this, the only way you can actually perfect at least a security interest in Bitcoin would be filing a financing statement. So that's kind of strange, right? Wouldn't you just turn over the private key? And and moreover, if you do it that way, if you are filing a financing statement, since the financing statement is a notice filing, it's filed against the debtor, meaning the transferor or pledgeor. Once you transfer it twice and you get to person C, there's no way for them to know who person A was. If person A has a lien filed against them, you'd have no way of checking that because you're dealing with B now. B's the one transferring it to you. So the notice filing just, concept just didn't align at all with the way transfers of blockchain assets work. And this, Article 12 aligns the law with.
So Mike, in answering
reality.
Kati's question directly, what should it be considered?
What it should
Control?
Yeah, well, that's transferring the asset is control. If you transfer Bitcoin in the normal way, then under Article 12, the transferee acquires control of the asset under Article 12, which aligns the law with how it works. Maybe
Kati,
Gordon-
does that answer your question? Yeah.
And by the way, we're going to definitely crystallize, because that's the focus of our seminar tonight. We're going to crystallize on what exactly it means to have quote unquote control when it comes to a digital asset like this. So yours is actually the best question, and that's our focus. So we're gonna come around. We're gonna run that around the track one more time so that you could be sure that your question's answered.
So let's look at page 12 and see the type of digital assets. This is an item 4, Gordon and Mike, that Article 12 deals with.
Okay, so it's important for you to know what Article 12 deals with and what it doesn't deal with. There's some clear exclusions, and I want you all to leave here with a clear picture as to what this is all about. When it comes to cryptocurrencies like Bitcoin, Ether, stablecoin, which is, by the way, completely different from Bitcoin in that it's pegged to a real world asset, a US dollar, treasuries or repo treasuries. That's what stablecoin is. The value of the stablecoin is actually fixed. So if you look at one of these charts of the movement of the value of the stablecoin is flat, Bitcoin is all over the place. That's the difference between those assets. So these are all, like I was starting to say, these are all internet native currencies that were created. In the case, the first Genius block for Bitcoin was on January 3rd, 2009. It's been around for a while. And in fact, these are living or native on a platform that we call blockchain, but it's really called distributed ledger technology. And then you have tokens that are nothing more than digital representations of rights with smart contracts and everything in between. They can be fungible or non-fungible, like art. So anyway, Article 12, to be more succinct, applies to all of those things, does not apply to central bank digital currencies, because that's actually considered electronic money, which doesn't really apply. So that there's some confusion about this. And by the way, one of the points that Henry will be touching on in a few minutes is Article 12 was meant to be technology neutral. They didn't want to hardwire something in and have it effective in 2026. And then lo and behold, the technology that it favored in 2026 changes over time, rendering obsolete Article 12. So it's technology neutral, which is to say all of the, and I have a little bit of a trivia question for you, all the technology is going to be applicable under Article 12. But here's the trivia question. How many cryptocurrencies exist today on planet Earth? I mean, I've named a few here, so I've given you a head start. Any guesses?
15 trillion.
I can't beat that. So, no, the answer is just a little bit under 18,000 cryptocurrencies exist today. And so these drafters, you have to sympathize with them. They have been in, very dimly lit rooms for years, and they don't want to have an Article 12 applied to a couple of them or a couple of the platforms. So that's why it's technology neutral. But anyway, the accounts that are maintained, some say wallets, are actually under Article 9. It's not an Article 12 animal, although those accounts ride or travel with the controllable electronic records. But that's all I wanted to sort of monopolize.
That's great. That's a wonderful, wonderful answer. And by the way, when we're doing the wine tasting and afterwards, we'd love to be able to continue to give you additional brain damage as we go through the evening on this. I wanted to turn, because I think it's an interesting topic, and I wanted to turn to my good colleague, Paul Kruger. One asset class that is really interesting that has kind of bridged the gap, wouldn't you say, Paul, to the ushering in of Article 12 is chattel paper.
Absolutely, yeah.
And would you be kind enough to kind of give some examples of what chattel paper is and how the amendments to Article 9 kind of put it on parallel footing with Article 12?
Absolutely. So I spend way too much of my time looking at rail cars, and not in the context of just looking at them on the tracks, but actually doing financing of rail cars. And an incredibly important element of that is the leases that go with the rail cars that generate the cash that, bankers and whoever else turn into bonds, into financing. And we've seen over the years, I guess, chattel paper security going from something along the lines of somebody having a stack of leases sitting in an office and taking possession of them through that mechanism, to, I guess, the electronic versions of chattel paper, electronic versions of railcar leases, which are gradually becoming more and more of a common feature. And the interesting thing with Article 12, chattel papers are not included in Article 12, is that the whole method of gaining control over electronic chattel paper is really a precursor for how control developed through into Article
Yes.
12.
Mhm.
And I think if anyone really wants to get a good head start on how control looks like, or what it looks like, take a look back at chattel paper and electronic chattel paper, and I think you'll get a fairly good feel as to what the law writers, the lawmakers were thinking when they started looking at control in that context. Now, I guess railcars being railcars, they're not easily converted into electronic form. So they have a completely different regime as well in relation to the creation of security interests, as do aircraft, as do boats. And if you take the time next time you're looking at a rail car, you'll see that each individual rail car has a unique identifier that indicates the manufacturer and the number. And that is then recorded from a security interest point of view with the Surface Transportation Board. So we're left in a situation where we have sort of these two different regimes, but equally important. And if you don't do one, no one's going to thank you. So you've got to do both to create this valid security interest over these assets. So combination of hard asset and chattel paper.
I would just add that Paul, correct me if I'm wrong, but some of the asset classes you all deal in with, in addition to railcar leases, are aircraft leases, which many of you are active in. Chattel paper also encompasses the auto industry, right? If I could put what chattel paper is in its most simplistic form, tell me if you agree or not, Paul, it's really a monetary obligation that is coupled together with a security interest or a lease, right?
And it has to be in a recorded form. That's the only thing I'd add to that.
Thank you. I would also, though, add to that physical chattel paper, right? Security interests, leases, etc., will continue to actually have the domain and be in the domain that they have traditionally been in. You may perfect a security interest in them by the filing of a uniform UCC1. However, if somebody gives value for them without knowledge of a claim and takes possession, you're not in luck. Because under Article 9, possession will trump in chattel paper. Oh, I did it again. Possession will take precedence over a UCC filing when it comes to chattel paper.
And I think, Henry, that's a really important point. And it's a misconception that a UCC filing gives you everything you want.
Right.
Right. You still need to understand how to control, even if you've got the UCC filing, locking up those assets is still an incredibly important part of an effective security package.
Yes. Let's jump to page, Paul, thank you for that. Let's jump to page 16. And I'm going to ask my colleague Mike to read to us, and it's bound upon it a little bit, but keeping in mind time, how control of an electronic record is obtained.
I can definitely read.
Since he moved to Seyfarth, his duties have increased.
It's definitely it's been hard, but the power to avail itself of substantially all the benefit from the electronic record. What does that really mean? Well, a CER. I'll expound actually. Why don't we read the rest of it first, then we'll expound. Also, the exclusive power, and notice the first one is not exclusive, but here it is, to prevent others from enjoying the benefits. So you have to be the only one, and you have to have the exclusive right to actually transfer to others control of the electronic record. Do you want me to expound a bit more?
Yeah, sure.
I will. So keep in mind, a CER in itself is nothing. It's a show about nothing, right? I think Sartre would be proud of it. It's just a concept. It exists in our minds, right? There's nothing attached to the CER. So the substantially all the benefit, particularly in the case of Bitcoin or something like that, really is nothing. But nevertheless, Bitcoin does count. That's a CER. The benefit is just having the thing. It's very broadly construed, and we'll go into the bit more how that compares with existing control regimes later.
Thanks, Mike. We're gonna continue to try to move the programmer along, knowing that we want to get to the wine tasting as quickly as we can. So we're going to actually jump into the section entitled "The Existing Law and Framework." Mike, if you can take us there. We've given you some background materials on electronic documents. We walked you through both the federal and state statutes, Ezra, New York, e-sign, federal, that provide for both the concept of electronic documents and also the affixing of electronic signatures to electronic documents, all of which has now been well established. For those of you who are lawyers, you know that they can be submitted in evidence into a court. They're given the same validity that an actual physical copy is given. One of the really interesting things when you get a chance on page 27, and I'm sure you all followed the enforcement actions of where bankers, and for those of you who are bankers in the audience, please forgive me, of how in establishing whether there was truly an agreement on electronic terms was the messaging happening through Bloomberg and other services. Fascinating to see how that all evolved. But essentially speaking, I'm going to say this very generally. You don't necessarily to have a document need to have a header. This agreement dated blah, blah, blah. You can create an agreement even through email exchanges, through text changes. It has to be shown that the terms are sufficient enough and that the parties intended to be legally bound. So we leave that for you to do some perusing. Ultimately, I think you'll find that the information that is there can be somewhat useful. Mike, one other thing I might ask you on page 29 is to talk about the concept under the UATA of what a transferable record actually entails.
Yeah, so this is the UETA is existing law. It predates Article 12. And Paul was talking earlier about transfers of electronic chattel paper. The mortgage market also works, substantially electronically. You have MERS, many of you are familiar with that, and electronic notes that represent the mortgage notes, and those are also transferred. those substantially rely on a uniform act called the Uniform Electronic Transfers Act, and also e-sign, which is a federal law. That latter only applies to mortgages. But UETA allows something that would be a promissory note under UCC Article 3, meaning it's just a payment obligation. I owe you this much at that time. That can also be under existing law prior to Article 12 transferred electronically as a transferable record.
Thank you, Mike. Moving on to page 30. Again, any questions? I appreciated Kati chiming in with a question, but any other questions that you have, please bring them up. We'd be delighted to do our best to answer them. But bear in mind, as you look at page 30, and I wish we had the time to do more of this, but essentially through either Article 12 or amendments to Article 9, this concept of control is actually broadened to include all of the asset classes that you are familiar with. One of the things, I would just point out, this includes accounts, this includes chattel paper, payment intangibles, promissory notes. And so ultimately, because many of you I have worked with on trade receivables deals, right? And we go through that extrinsic list problem, right? Where a UCC is filed, and in order to try to gain a perfection in the account receivables that are created in a trade context, it lists an extrinsic list to the UCC because it says the security interest in these assets includes all of those who are listed on Exhibit A to the purchase agreement between the parties. Now, that's of very little value because you never get to see Exhibit A. It's the proprietary work of the banker and the originator of the assets. And so many times we have to wind up to know that these assets have not been double pledged on simple reps and warranties that come from the originator. And we all have seen countless frauds in the market of where parties have double pledged the assets. Through a combination of Article 9 amendments and Article 12, we will be able to come up with an electronic method to perfect the interests and accounts through a method that allows just one way in which to identify the assets and in which to transfer them. So I think there will be a real improvement in that. And that, for those of you who are involved in the trade receivables finance business, I think that will be a significant improvement for you. Moving on through the presentation, because Erin, by my clock, I think we just have about 15 minutes left. By the way, I failed to mention up front that there's CLE credit available for tonight. And so Erin, who has so wonderfully put this together, as Gordon noted, will assist you on doing that.
QR code is on the last slide also, for those of you who are lawyers.
Thank you, Mike. There's a couple of things we should talk about is in the context of what it doesn't cover. Now, for those of you who operate in either the resi or the commercial real estate area, you will know what we're saying is the case. So Mike referred to this before, that there is a MERS system that allows you to put in the name of a third-party trustee the ownership of the mortgage, right? And generally, when you go to sell the mortgage, you just the trustee's name does not change, but the trustee is now holding on behalf of a new party. That's not going to change. MERS is still going to be a valid basis under which the mortgage will transfer. But even more importantly, an amendment was made to the UCC. I'm sure Mike Keenan, who lives in the resi area, knows this. The mortgage follows the note, right? So whoever is perfected in the note is perfected in the mortgage. The notion there is most jurisdictions, and it's changing a bit, but most jurisdictions, when you have to go and enforce a mortgage, the recorder's office will not give credence to anybody who is not a registered owner of that mortgage to foreclose. And that's why MERS has played a valuable role in that market, because the owner of the mortgage doesn't change. When you transfer the mortgage, it's still the MERS trustee acting on your behalf. In many ways, it's like a mortgage DTC, right? In DTC, the owner of the mortgage of the securities is not registered in DTC's records, but who is? The DTC participant, right? So the DTC participant remains the same, even though you may have a different beneficial owner of the securities, and MERS acts in that behalf. Mike, is there anything you would want to add or subtract to that?
Not at all.
Thank you, Mike. Appreciate it. He's my former associate, so he's the plant in the audience to make it appear like we know what we're talking about. Thank you for that, Mike. Mike, one last thing for this before we go through the example on the digital side. Let's just go to page 39. And I'd like you to just walk through the concept of how this electronic control has been done through the concept of what we call an electronic collateral control agreement, which generally we refer to as an electronic vault. And Mike, I thought it might be valuable for us to take a look at the diagram that is on page 57. Am I correct, Mike? That shows how the electronic vault is constructed, not 57, 56. So if you could just walk through that really quickly, Mike, and then we'll go into how this app applies to digital assets.
Right. So Henry, so this is a lot like DTC, right? You have a person that runs the electronic vault. Here we have eOriginal. It gives electronic vault services for chattel paper and sometimes for electronic notes. It runs the book. So it records who owns what item of whatever you put in the electronic vault, be it chattel paper. Now you can do accounts and you can do payment intangibles. So really any kind of intangible asset that you have, be it an unsecured consumer loan, for example, a secured loan that's not secured by goods, not chattel paper. Really, a lot of the stuff that you work with can now much more easily be perfected and transferred through a mechanism like this, which solves a lot of the issues that Henry was talking about, the really difficult due diligence, fraud issues that you have with filing, financing statements that reference extrinsic lists. Here you really have a very good environment. This is actually used a lot by the fintech platforms, but I think we see now the flexibility in the law probably lead. If you're lenders, by the way, out there, and we don't judge you for being lenders, but if you're lenders, this is what you want your borrowers to do. You want your borrowers to set up a system like this. You can track the asset as it goes in. It gets electronically signed. There's just one of them. It goes into the eVault, and it's very clear who owns that asset. You have perfected interest. It's prior to anyone else out there in a way that's unequivocal and verifiable. So I think it really is. I think we really are going to be going in that direction. I won't go through too many of the details of the plumbing here.
That was great, Mike. Anybody with questions of how an eVault works? Okay. Yeah, Kati. Yes. My second plant, Kati and I worked together for many years.
I'm still trying to understand how to detect fraud. So somebody pledges collateral through the eVault, and then they can't repledge it, obviously, to another lender because it would be detected immediately. Is that how that would work? But how do you know? Like, does it get a special identification code that you can match? I mean, if you go to a different eVault provider, would that still be detected or not?
So yeah, that's a great question, and that's exactly what this largely does. Now, could you conceive of a situation where you could commit fraud even with an eVault? Sure, you could try to put it in twice in the system or something like that. But there are controls in place, ideally, to prevent that. So each loan gets a unique identifier, and then all the loans of the originator are in the vault. then and the custodian can verify that that loan number has not been assigned to someone else. We've all seen situations where by mistake or intentionally, someone has sold the same loan to multiple people. They have conflicting interest. It's really hard to track that down. It's a large effort with due diligence, and also even the documentation. These are advantages that aren't necessarily UCC type advantages, but using an electronic system assures the standardization of the agreements, for example, or can help do that, can assure the documentation is there, automates the process generally, which helps with your
And
diligence.
Kati, just to add to that, the party who has the ownership right of the CER is the only party who can direct the custodian with regard to that.
I think
So
it's
that's a
important.
really important point.
I think it's actually important we point that out, because the CER, this is probably a big part of Article 12. As I said earlier, CERs are a show about nothing in and of themselves. The CER is just the record. So if you have a CER that represents an interest in art, which is goods, then you're still, if someone has an interest in the goods directly, and you just have an interest in a CER that represents, a fractional interest in art that's held by some custodian, someone has a claim directly against the art, then you're still subject to that. But there are exceptions. There are two very important exceptions that under Article 12, the controllable account and the uncontrollable payment intangible. Those are directly fused to the CER, so that when you get one, you get the other, and your interest in the account is prior to anybody else's claim to the account.
Thank you, Mike. Before we close out the program with an example Gordon will provide in regard to the token financing, because we've tried to combine both traditional and digital assets in this. Paul, you're fairly active in the trade receivables area. And what do you see Article 12 adding to sort of the way supply chain financings are done?
Well, I guess microphone's on.
Yeah, you're on.
I think for a long time in supply chain finance programs, people were trying to come up with ways to change the nature of the payment obligation. So, for example, you'll see documentation that provides power of attorneys flying all over the place to create negotiable instruments, where there was a physical piece of paper which would almost replace, in fact, it did replace the underlying trade receivable obligation, so that the holder of the payment obligation had something that they could simply go and enforce against. Now, that was incredibly cumbersome, but I think what we now have the opportunity to do is to create electronic negotiable instruments that are generated without the need for paper, without the need for possession and control through a physical piece of paper. So I do think we're going to see quite an interesting development in that area, Henry.
Thank you, Paul.
Just the one important distinction there is when you did that in the supply chain deals, you created a negotiable instrument. And Article 3, a negotiable instrument, you become a holder in due course. You're free of not only property claims, but also defenses. So you sold goods to someone, they were lousy. You have a right to return the goods. That's a dilution. People know the term dilution in the market. That's a dilution that reduces the claim. If it becomes a negotiable instrument, then you're free. You take that free of defenses. So the buyer still has to pay the holder of the negotiable instrument, irrespective of any defenses they might have. You can do the same thing, but you just have to get a waiver under the Article 12 regime without having to go through the extra step of turning it into a negotiable instrument. Now your account becomes that account receivable, that's an account, that becomes a controllable account. You can just put it directly into an electronic vault and transfer it. But to achieve full negotiability, you have to get the account debtor to waive claims.
In Mike's documents, the term lousy is in the defined section list. So
no, that's an incredibly important point. And I think, though, we can't lose sight of the fact that requires cooperation on the part of the buyer of the goods. And also from the supplier's point of view, they're looking at this and saying, well, hang on, I thought I had this wonderful receivable sitting on my balance sheet, but now you're telling me I have a negotiable instrument, or I've got the CER thing floating around. So I think it's going to require a fair amount of what I call sort of panel beating and, the market changing for this to be a viable way of structuring supply chain finance programs.
yeah, we'll have a lot. Thank you for that, Paul. I think we'll have a number of suggestions to you as our clients as to what we'll be putting into documents to establish the concept of the CER. And the obligor, for example, under a trade receivable will need to acknowledge that it will pay the holder of the CER. So we'll be doing some revamping of documents to make this move into the new age. So in the last 5 minutes, Gordon, let's go to page 58. Let's go through your example of how a token financing is achieved under new Article 12, and then I'll just have a couple of closing remarks.
Okay, but those are the last pages standing in between us and wine. So let me try and do it in 3 minutes, if that works.
That's wonderful.
Okay, so here's the Reader's Digest version of this scenario. It's a revolving credit facility. It's a $900 million typical revolving credit facility where the first draw is $25 million on the date of closing. I've got two hypothetical parties, Empire Ledger. What do? They develop tokens. Digital National Bank of New York, I came up with that. That's our lender. What they're doing is grappling with the before and after pictures of Article 12, and here's how it looks. Slide 59. So the tokens as collateral, third bullet point on page 59, live on a public blockchain and are custodied in what we call a multi-signature, multi-sig treasury wallet. Perhaps two of the keys are maintained by the borrower, a custodian or a lender maintains a third key. That's what multi-sig means. All right. The lawyers at the bank treat the pledged Bitcoin and tokens as general intangibles. That's what we heard first in this seminar, which is in the pre-Article 12 world, the only way that they could really characterize this and use the legal protocols properly was to call these things general tangibles, intangibles. So they would basically have to file a UCC1 and then hope that, you know, the pledged collateral wasn't subsequently encumbered or sold or what have you. The perfection was done that way. UCC Article 9, of course, didn't have any digital asset specific take-free rules, no qualified purchaser sort of safe harbor, lots of hand-wringing. Therefore, the haircut on the pledged collateral was so high, at least 50%. The spreads and the credit sort of desk, the credit desk at the lender would, of course, be wringing its hands as well. And everybody loses all sorts of insecurity. Collateral that really is good collateral is not given its due. So on page 60, again, going quickly, they negotiate this term sheet in the pre-Article 12 UCC Article 9 world, and then a big development happens. Signed into state laws, of course, the new Article 12, the collateral is truly CER, controllable electronic records, either tokens or Bitcoin fit that. And the bank says, whoa, slow down. We have a much better situation here, much more clarity for when this defaulter possibly defaults, and much more clarity as to what, if anything, we can do to control this. Because the punchline is, once you have control, it doesn't matter who files a UCC1, control takes priority over that UCC1 because of Article 12. That's the gift to the market for both sides. So this hypothetical bank has its lawyers call back the borrower into its conference room and say, let's revisit this now. We're going to make you sign Article 12 compliant documentation. So we have a loan agreement that's Article 12 compliant. We have a pledge agreement, Article 12 compliant. Now we have an account control agreement, and many of us have done them, that is Article 12 compliant, which answers your question earlier as to what is control. So all the three elements of control, the ability to enjoy, the ability to not have others enjoy, the ability to transfer, and the basic publishing of who is controlling this, all wrapped up. And with those elements, the bank has control. Doesn't matter who else files a UCC1. After June 3rd this year, that's when this becomes effective. That bank can have priority and security and confidence that that collateral, if there's a default or if they need to sell it after a default, they have confidence that they're the only party in the world that has control. And they can do that well on the blockchain because they've got private keys. And that's what blockchain and Bitcoin was designed to do, is to avoid double spending and so forth. So we waited a long time. New York, typically, for a very good reason, I might add, is sort of the late adopter of something like this, and I think I've exceeded my 3 minutes.
No,
That's the
you,
longest
it was
3 minutes you've ever seen.
magnificent in 3 minutes.
But that's the scenario.
So all I would say, I think it's probably the program has highlighted the need for all of us to be working together to make sure Article 12 is a success, and actually that you don't get caught red-handed. Like, as Gordon has said and multiple people have said, once we're through the transition period, control is going to preempt filings. And you might find yourself out in the cold, right? So hopefully that's all been somewhat clear. The rest of the materials are just some good background reading on choice of law and the transition rules. I would just like to say thank you for the wonderful turnout. I couldn't be happier with the folks that made it here tonight. We're very grateful for that. We're also very mindful of how much there was to cover in the time frame. So if any of you would like more detailed, more tailor-made programs on particular assets you work with, we'd be delighted to do that with you in a meeting, a teach-in, a conference call, whatever might work best for you. But that's what we're here for. Please remember to take your books. If you forget, don't worry, we'll send it to you electronically. If you want some extra hard copies, they're up here. And please take your goodie bag with you as well. And please join us for the wine tasting. Thank you so much.